It's a particular pleasure to follow the Right Honourable Lady. I thought her speech was very well thought through and persuasive. We don't always agree on these issues, but in one aspect of it, she persuaded me, and I'll tell her in a minute what that is. Because in this area of argument, which goes right to the heart of what makes British justice special, and at the same time goes right to the heart of our national security, we are, all of us, inclined sometimes to put things rather too heavily in black and white. Now, I have every sympathy with the agencies who are trying to preserve their own security. They have plenty of threats to them. Past agencies, the David Shaylers, the Richard Tomlinsons leaking their information, even ministers. I remember Ted Rowlands once in this House gave away some crown jewels. But most ironically of all, of course, also Washington. Because given the genesis of this bill, some of the biggest leaks take place with our biggest ally. Whether it's Pentagon Papers 40 years ago or only 2 months ago, what sounds to be in the British papers, the putting at risk of the life of an Anglo-Saudi agent, which they used in one of their operations and then talked about afterwards. So nobody would, and certainly I, would not challenge the right of the agencies to preserve their own proper security. And I stress proper security. Yes, I will.
I'm very grateful to my right honourable friend. I mean, he mentions the time and how things have changed over 40 years ago, how things have happened. Noticing this debate, it's very clear time has moved on. The clandestine community is very different than it was in the past. It's now scrutinised in a way that it's never been done. We can now mention, John Sawyer, Jonathan Evans. These are names which you couldn't even mention in the chamber, let alone MI5 or MI6. Would you concede that there is a new level of scrutiny that we're now having to look at, and that's why these CMPs have to be brought into place? 40 years ago, we couldn't even be discussing it.
Well, as one of the two junior ministers who took the Secret Intelligence Service bill through the House and asked the then head of MI6 whether he really meant this, I can take his point. But the simple truth is that we have to live up to those standards of accountability. And that means open justice wherever we can have it. Now, one of the interesting divides that's taken place in all of this is almost a generational one. We've only had closed material procedures really since I'm looking at the then 97, 98, anyway, 97 certainly. Only really for a decade or two. Now, there is a generation of special advocates who have taken a very strong stance on this. Why have they taken a different stance from everybody else? Because they have experienced both sorts of procedure. Nearly all of them have understood the closed material procedure personally, and also the PII procedure personally. And you talk to most of them, they know both procedures inside out. And one of the things they argue, a point made by my honourable friend, the member for Chichester, in his, what I thought was an excellent, brilliant speech, in fact, which I agree with every word of, the point he made was that PII has been misrepresented. And if you talk to any special advocate, PII is a much more complex, judge-created, judge-evolved process than is being represented. Of course, there could be simple blocking. Of course, in addition, there could be redaction. Of course, there could be circles of confidentiality. Of course, there could be in-camera hearings. Indeed, the Minister without portfolio rather dismissively said, this is the system that gave us arms to Iraq. Well, even in that process, which involved at least two ex-minister, or one ex-minister, one minister in the House today, even in that process, early on, as it were, in the development of PII, we saw one category of certificate refused, one category accepted, and one category heavily redacted. And that gave the court enough information to make Alan Clark face the interview, the interrogation, in which he came out with those famous words, being economical with the actuality, which collapsed the case because the prosecution recommended an acquittal on the basis of evidence that came in. I give way.
I thank the honourable gentleman for giving way. Just to continue to emphasise the PII point that he's making, he will be aware of the fact that at this moment in time, and for many years in our country, operations have been carried out, covert operations have been carried out, which have been used, the evidence obtained from them, to convict people, yet the methodology used where the operatives were, the locations were always kept secret, and that was part of the PII application. PII is not about excluding evidence, it's actually about including evidence. It's just they're not letting the other side know what you're adducing, and therefore everyone here seems to be, or majority of people here seem to be working on a totally wrong basis what a PII is.
She, of course, is right, but let me just get to this point, the point I was trying to drive towards in this, and that is that none of the systems we're talking about are perfect. PII clearly has weaknesses too. And I don't think, I mean, everybody who's spoken has said something to that effect, and the Honourable Lady was particularly correct about that there are weaknesses to PII. So we shouldn't accept that that is the perfect outcome either. But now come to close... whichever. I'll give way to the Minister.
I'm grateful to my right honourable friend. I mean, he quite rightly says that in PII, because people don't like excluding all the evidence, there is a perfectly legitimate argument how much of this can be gist, how much can be redacted, and then we can put it into the open court. But everything that doesn't get there is entirely left out. It's not available to claimant, judge, lawyers, or anybody else. In CMP, you can do exactly the same things. The judge is going to be required to consider how much of this can be gist, how much can we redact, what of this can be shared with the defendant. The only difference is in CMP, the evidence, including, as my honourable friend said, some things which may be absolutely key to the case, which can't, unfortunately, be disclosed, can be considered by the judge. PII is to shut out all that which is not possible to gist. You can still do all the gisting and all the redacting you want with CMP, but all the evidence is considered.
I'll give way as well to my honourable friend.
Well, I'm grateful to my honourable friend. As a minister who did indeed sign a public interest immunity certificate in the Matrix Churchill case and was vindicated by the Scott inquiry for having done so, may I say to my right honourable friend, yes, of course, some things can be permitted through PII. As my right honourable friend, the Secretary of State, has said, the real issues that would damage national security cannot be considered either by the judge or by anyone else. And I make one other point to my right honourable friend. He does perhaps not appreciate that even when closed procedures may be approved by the court, once special advocates have been appointed, if the special advocate, having had access to the secret material, puts forward a convincing case to the judge that some of that need not continue to be held under closed procedures, but can be held in open court, the judge, if he is persuaded of that, is perfectly free to do so. So the special advocates themselves, unlike their clients, can put forward that argument, have done so in immigration cases, and that is a point which has not been mentioned in this debate so far.
And I don't dispute any of that, in fact. I mean, I think this is where I'm coming to with respect to the role of the attitude of the special advocates, because clearly, of the two, they do not like CMP, and for reasons I'm now about to elaborate. Now, it doesn't mean it's impossible to use, but it does mean restriction is the order of the day. And the best outlining of the weakness of closed material procedures was Lord Justice Kerr, who said effectively, I mean, I'm now desperately paraphrasing him, that unchallenged evidence can be worse than use. He actually used the word misleading. It can be misleading, and this came up any number of times in the Lords debate on this. I mean, a number of lawyers in the Lords, Helena Kennedy, for example, cited a case of a tape recording played in court, a recording of a conversation which appeared to convict or incriminate a defendant. It then turns out, when the defendant heard it, he said, well, actually, no, I'm sorry, but I left after about 5 minutes. They then listened very carefully. They could actually hear the door opening and closing as he went. There you had a piece of evidence which appeared to be incredibly incriminating, became actually not incriminating at all. David Anderson put a similar case, a similar point to the Lords Committee when he was giving evidence to them too. So the issue of challenge is very important. It is critical to our judicial process. Completely different from many other judicial processes around the world. The challenge is vital. Without the challenge, the judicial process is not operating properly, which is why I think that we have to take on board what the special advocates say and effectively build it in to the structure of what of the bill we're passing. namely to create, as it were, a hierarchy. You have to go through this thought process. Now, I'm cognizant of the point that the Minister without Portfolio said. You do not want to have a minister pinned down for a year working on one PII, and I'm quite sure, I know from my own experience, that some of the Guantanamo cases are incredibly complicated with very, very many documents. So I do not think it's beyond the ken of this House to be able to achieve that. Now, I will support the opposition's clause on amendment on this today, but I am open to argument if we can find better wording for it to get what we're trying to get, which is a hierarchy, a priority, which says first open hearings, then the PII process, if that's appropriate, if not CMP in the final analysis. And quite right, I agree with my honourable friend, my right honourable friend, the member for Kensington and Chelsea, that that process should be more open than it currently is. Yes, very briefly, please.
I'm very grateful to the honourable gentleman who's making a characteristically interesting speech. He's referred several times to a hierarchy in relation to openness, and in that hierarchy he places PII above closed material procedure. I'm sure the House would be interested to know what his rationale for that is.
Well, all right, let me give him an example. The question is whether or not you can challenge. If the evidence can be in court, it should be capable of being challenged. Now, there is an example which is, let me see if I may have it here. Yes, I do. There's an example which goes back to 2006 in the current CMP procedures used in SIAC. And in SIAC, there was a case brought, and I'll just read the note. This is a Press Association release. A judge in a secret hearing has criticised the Home Office over contradictory MI5 intelligence in the trial of 2 terrorism suspects. The intelligence only came to light because, by chance, the same barrister was acting in both cases. Mr. Justice Newman said the administration of justice had been put at risk in the trial of Algerian Abu Doha and a suspect known as MK. Both sets of contradictory evidence had come from MI5. Now, what it was they had a false passport, which they claimed was being used by 2 different people in 2 different places at the same moment on the same day. So it clearly was impossible. That only became apparent because you had the same barrister acting as a special advocate in each case. Now, we do not, the problem is there was no process of challenge. Of course, if there had been a process of challenge, it would have been denied and it would have been struck out. As it was, both cases were struck down because this was clearly an implausible case. And that process of challenge is vital. So for that reason, I'm entirely with the JCHR in terms of what they want to see. They want to see gisting, if it's possible, and this is the point where the lady was persuasive. If you'll forgive me, no, I'm just coming to an end. The lady was persuasive to me in terms of there being some sort of opt-out and gisting if it really is serious, then the judge should make it only the judge should make that. And I take that point. That's not a bad. That's a very good argument. That there should be judicial balance, proper, explicit judicial balance in a decision to go to CMP, which takes into account all the interests of justice, not just national security, and that there should be the argument of strict necessity. That's what I mean by the hierarchy. And it seems to me on that basis, this House will come to a conclusion which we've got effectively the best of all worlds.